wants the. Good morning. It is May 17th, 2022. This is a public deliberation of the Baltimore County Board of Appeals in the matter of Rock Realty for the development known as Southern Crossroads at 4100 Maple Avenue. CBA case number CBA-22-042 on the appeal of approval of a development plan, a January 27th administrative law judge development plan opinion and order, which corrected the date to January 26th. So it was January 26th development plan approval. As you may recall, this is a townhouse development in the Halethorpe area on the old Good Shepherd School property. There were a number of appellants, including the Halethorpe Improvement Association and several individuals, William Carter, Michael McAuliffe, and Tiffany Weisman. So I'm going to let Mr. Evans start. Having gone through everything, where are you on this?
Well, let me just say one thing preliminarily. There was some concern about whether Halethorpe Improvement Association should be a party to this, and Mr. Vittori was invited to submit something on that, and he didn't. And my view is that HIA is a valid party. I don't think Rule 8 is disqualifying under these circumstances. I asked Mr. McAuliffe during his testimony where there was anything he would say on behalf of the HIA that he didn't otherwise say, and he said that there wasn't. So any concern about HIA's status as a party, I think, is moot and irrelevant. I also want to, I feel like I owe Mr. McAuliffe a little bit of an apology. I feel like I was short and intemperate a little bit with him at our hearing, and you know, there's no call for that. And so I do want to just make sure that it's clear that my intemperance and my crankiness wasn't intended to be, certainly not intended to be personal, and certainly not intended to be reflective of my view of the situation. So
we attribute it to your age.
Yeah, well, that's probably right. Anyway, I did want to make sure that was on the record for Mr. McAuliffe. In general, getting then to the merits, in general, I have no, with one exception, I have no real issue with the development. I mean, you know, our review is very deferential, and in other words, we're required to defer and respect and accept the findings of the administrative law judge, even if we disagree with them. It's, you know, reasonable minds can differ about many issues, and as long as there's a reasonable basis in the record for the ALJ's decision on any number of these issues, and there are a host of issues that she was required to address. And so for the most part, I think she did a very, very, very commendable job. And I don't, her opinion appears to be a pattern with her. Her opinion was lengthy, but it did address the issues. And for the most part, as I say, I don't see anything that wasn't satisfactorily established or proven or that was otherwise unlawful, with the one exception that I'm about to get to now, and that is the pedestrian path. And the pedestrian path that comes right up to Ms. Wiseman's property line, 2 feet from her property line, 2 feet from her driveway, 2 feet from her garage. And I might add parenthetically that I view this notion that somehow somehow this is her fault because she got a variance. I have very little patience actually with that argument. And I mean, she got a variance because no one in the civilized world ever believed there would be anything on the other side of her, that her setback was, the 10-foot setback was complete irrelevancy in context. And there was no reason to not permit her garage to intrude upon the setback. It's a completely understandable situation. There isn't anyone on the Board of Appeals or in the Office of Administrative Hearings that wouldn't have granted a variance under those circumstances. It was probably unopposed. So I have no sympathy with the notion that somehow she invited this problem. I think that's an argument only a lawyer could love, frankly. The second point is that the proximity of the path to her house is, to my mind, it's a highly, highly, highly significant invasion of her privacy. I think it's a privacy issue. I think it's a security issue for her. I think that those are real and palpable issues. I don't think that's hyperbole. I don't think that's just rhetoric. I think it's true. I think that they cause an identifiable diminution of her property values. I don't think anyone wants to buy a house with a path that close. And I think that under these circumstances, given the type of notice that there is for these hearings, or it's not even a hearing, for this ruling, there isn't even a hearing in front of an office. There isn't a hearing, there isn't an adversarial process in front of some administrator. I mean, this is just someone at his desk who receives a submission from the developer and then issues something. That's all this is. So with notice on the internet, and the notice is, I didn't look at the notice, but it's opaque, undoubtedly. And the same is true for the issuance of the opinion. I mean, such as it is. So when you have a diminution of the property values that is authentic, and you have notice of this sort, which is not particularly good notice, and it's not like they didn't know about it. I mean, my gosh, the hearing was going on. The hearing was actually going on when this happened. So whatever you might want to say about whether the developer, whether his conduct was appropriate or not, certainly, the government is required to be more attentive to all of the citizens. And this smacks of, I don't know if it is, I could be convinced of it, but I don't think it's necessary to reach it. But there are actually, I think, at least due process implications here of a deprivation of property without notice, without an opportunity to be heard. But having said all that, I do think that there was an error of law, actually, by Judge Murphy. And please apologize for my length here. I made notes, and I'm trying to be careful in my in my comments here, I'm not trying, I don't want to just, anyway, I'm trying to be careful. So there is an emerging doctrine. There's actually a case in the Court of Special Appeals that announces this, that says that an appeal under these circumstances, that the decision, I should say, the decision from DEPS was not final at the time that it was made, and that it was an appeal, that to have taken an appeal at that point, had she even known about it, would have been interlocutory. This is the principle articulated in Chesapeake Bay Foundation versus Craig Westport LLC at 252 Maryland App 470. This was decided on September 8th, 2021. Cert has been granted in that case by the Maryland Court of Appeals, but I came to understand, I learned something, that a case continues to have precedential value even when cert has been granted, and that was apparently that's a well-established proposition. I never had the opportunity to delve into it, but there's a case called Berry versus Epps, 506 F 3rd 402 at page 405. This is a Fifth Circuit in 2007, said that cases where cert has been granted are, continue to have precedential value. So in any event, what happened in this Westport case is that in the context of a development plan, there was an adverse ruling, an adverse administrative finding of the sort we have here. And the Chesapeake Bay Foundation took an appeal, and ultimately it was held that appeal was interlocutory, because in the context of, and that was, the developer was making that argument, in the context of a development plan, there are any number of agency findings that have to be made and that are subordinate to the overall development plan. And so when and if it was appropriate to take piecemeal appeals, then there would be this bizarre set of parallel litigation, presumably, all of which might be moot if the plan was changed, or if the plan was not approved, or any number of contingencies. So it's a huge waste of time and effort to have these little separate sort of severed pieces of the worm out there trying to grasp some sort of time in the sun here. So I don't think that I would rule that the agency letter of October, whatever it is, 14th or 15th, is not an appealable order. Rather, it is better viewed as something that should have been either addressed by the ALJ or somehow afterwards, at a time when its appropriate context could be understood. I mean, what would happen if it took a year to decide that? Let's just do a thought experiment. What happens if Ms. Wiseman had appealed that, and in the meantime, the development plan is approved, but the entire development is delayed while the Board of Appeals, and then the Circuit Court, and then the Court of Special Appeals considers DEPS's agency finding? I mean, it leads to an absurd and preposterous result. So therefore, and I would add that that logic is even all the greater by reason of what I referred to earlier, which is this whole thing, this agency finding, so to speak, was in the middle of this hearing. I mean, how preposterous is that? It's in the middle of the hearing. So, and there's also a colorable, moving on, I'll finish up here. There's a colorable claim that Ms. Wiseman was misled. And again, that claim I reviewed Ms. Wiseman's testimony before the administrative law judge. That issue was fully developed in front of the administrative law judge. It is before us. I would prefer not to reach the question of whether she was affirmatively misled by the opposing party. That's an unhappy and unattractive set of circumstances that I prefer not to reach. I would if pushed, but prefer not to. At the end of the day, as I say, I believe there was an error of law in the administrative law judge. I would approve the plan, the development. The bottom line for me is that I would approve the plan with the exception of the quarter-mile pedestrian path. And that, I guess, I would just eliminate. I would just order that gone. And I mean, I don't know, honestly, I don't know whether there are revisory avenues after this is all over, whether it could be redirected in some fashion. But at least for the time being, at least for today, my ruling would be, for the reasons I articulated clumsily, my ruling would be to affirm the plan with the exception of the path. And the path I would simply excise from this. And finally, I guess I just want to say one final thing. I don't want to, there is no one listening to this deliberation or participating in this case that would tolerate having this path 2 feet from his or her house. I mean, please let us try and not be horribly legalistic about life in all its forms. This is not tolerable. And frankly, you know, the agency decision doesn't even address it. It doesn't even give lip service to Ms. Wiseman's predicament. Doesn't even give lip service to it. And there isn't, you know, the author of that letter wouldn't want to live in Ms. Wiseman's house. I mean, it's just not right. Okay. And I don't want to be too highfalutin and moralistic. It's an unattractive quality in anyone, but it's important to have some context here. And the context is this is not right. This is really, really, really not right. So that's my take.
Ms. Bernardi?
Thank you, Mr. Evans. And I reached the same conclusion, maybe a different way. And I too have concerns around the notice piece. I mean, it arguably may be legally sufficient, arguably not. There was lack of transparency. There were numerous conversations that were taking place with Ms. Wiseman, and never was there a conversation around this proposal that they were following. And so I have concerns with that as well. Ms. Wiseman also brought to our attention that there was supposedly a fence that was going to be constructed. There's nothing in the plan that actually identifies that fencing, and even with that fencing, I don't believe that it provides sufficient relief for Ms. Wiseman for the many reasons that you stated, in addition to the security, the invasion of privacy piece, and the at least constructive taking of some of her property. Other concerns that I have is Ms. Wiseman did make reference to the erosion protection piece. I don't think that enough consideration was given to that argument, and she did present during her testimony support for why we should give consideration to that, in addition to the other issues that you raised. And so I would agree with the recommended action, and removing this footpath from the developer's plans.
Thank you, Ms. Bernardi. And interestingly, I concur, and I came to it a little differently than either of you. And the way I got here was twofold. One, that path is so close to the stream, which Ms. Wiseman demonstrated with pictures and testimony, is eroding, that I don't think there is any protection for the resource, which is why there's a buffer in the first place. But on the larger scale, I was around when these development regulations were adopted. The developer gets the benefit of what we then called front-end loading by putting everything on the table before the commencement of hearings. There was a community input meeting. Ms. Wiseman participated. This issue was raised. There was a hearing scheduled in July, which got postponed. Then it was rescheduled for September, 2 days in September. Certain of the developers' submissions had not been made or completely reviewed. The developer's in the driver's seat here. The idea is to be able to provide a full picture to interested parties at the outset. That didn't happen. It was after 2 days of hearings that these submissions were dealt with, and contrary to certain provisions in the code, this information was not submitted, or availability of this information was not sent by written notice as required to all identified participants. I think that procedurally, the way these variances, both in the timing and the manner of any notice, were flawed and failed to meet both the intent and the letter of the development regulations. In addition to the fact that putting a path within a minimal distance of a water resource defeats the whole purpose. But from a legal point of view, I just think the process, the procedure was inconsistent with the development regulations, and I too would eliminate that portion of the path. If the developer wants to work out a different location, he would have to comply with the law and give the appropriate submissions and notices, as would the county and through the director of the Department of Permits. But I would concur 100% with both of you, even though we each got there slightly differently. Were there any other issues that were raised that, where we disagree with the ALJ's findings?
Well, not for me. I mean, really, I mean, her findings are detailed and in depth, and she certainly didn't rubber stamp this. And
No, she didn't.
and,
She didn't grant everything. The other thing, Ms. Wiseman's testimony also said the developer would explore alternatives. If you look, I think it's his Exhibit 52, the application for the variance basically says there's no alternative to this path. So there was no exploration of an alternative in the alternatives application or analysis, which she was not privy to. So
right.
anyway,
I don't know if there are alternatives that can be done at this stage. I would hope that in the interest of economic efficiency
in judicial economy.
and judicial economy, that the matter would end here, that, but, you know, who knows how committed the developer is to this short little path, but, it's not, I mean, it's not an attractive situation.
Well, it doesn't serve the development particularly.
Right,
The
right.
justification is to serve off-site community. The off-site community does not have a really terrible alternative. I've looked at the aerials and the maps, and I also want to say, in general, this is a good development. It's an infill development. It really positively repurposes an obsolete facility on a very difficult site. It had, you know, we may all wanted to do things differently, but we're not the initial fact finder. But from a global perspective, there is a lot to commend it.
I agree with that as well. Yeah. Yeah.
Okay, so we're in agreement?
Yep.
Yes.
Then I'm going to conclude this deliberation. We then unanimously will affirm the ALJ with the exception of this walking path that goes from some local open space to past Miss Wiseman's house. And that's our decision. And
Great.
thank you both.
Thank you.
Thank you.
Thank you. Mhm. Bye-bye.
Bye.